I'm extremely grateful to the Bar Council for allowing me to give this lecture. I'm gratified to see how many of you are here. In a recent article I wrote about this very topic, I said that I got to a stage where I felt I was having a conversation about it with myself in an empty room. Now, I'm sure that most people, when they learned that I was going to give this lecture on this subject, must have sighed and thought, oh no, his obsession, he's going to bang on about it again. And so what I thought I would do is I would write a definitive text on the subject, about which, so I thought, modestly, there really couldn't be any argument. And so over some time, I produced what I've called a monograph. It certainly is comprehensive, but unfortunately it comes in at 32,000 words, which is longer than Hamlet, and which at my normal speaking rate of 140 words a minute would take 3.5 hours to deliver without an interval. And I can see you looking nervous already, looking at your watch. Fear not, the monograph will be made available to anybody who wants it as soon as this lecture is over via the Bar Council's website and the websites of Class Publishing and the Financial Remedies Journal. I'm going to give you selected highlights from the monograph with pictorial illustrations. These abridged highlights do more or less convey the substance of my arguments in the monograph, but they shouldn't be regarded as definitive. Now, why have I gone to so much trouble? I've done it because I am profoundly concerned at the position in which financial remedy practice finds itself in terms of compliance with the general law. Now, for non-family practitioners here, and including our friends from Holland, I should explain that when I refer to financial remedy practice, I'm referring to, there's normally a fine for that, I'm referring to what used to be called ancillary relief, which is the process and the powers whereby the financial aspects of divorce are settled or adjudicated. These days, these cases are heard by a specialist court called the Financial Remedies Court, which is a sub-court of the Family Court. Now, government statistics show that in 2024, there were 10,500 financial remedy cases which went all the way to a final hearing, 10,500. Now, put that in context. Excluding the small claims track, in the county court, there were in the same year 11,000 civil trials. Now, that's for all types and all tracks of civil claims. So 10,500 financial remedy claims go to final trial, 11,000 civil claims, excluding small claims, go to judgment in the county court. So, a post-divorce financial remedy claim is by far the most numerous type of financial civil claim tried in this jurisdiction. And they are all heard behind closed doors. A tiny proportion, 1% of the judgments are published. And of those, 85% are anonymized. So to be precise, in 2024, out of 10,500 judgments, 10 had the open justice principle applied to them. Now, 10,490 judgments were shrouded in a mantle of secrecy, and it's this phenomenon which I contend is non-compliant with a core component of the rule of law. So on to the slideshow. On the slideshow, there are 16 pictures of famous, and perhaps not so famous, people who play a significant role in this story. And I'm going to play with you a form of bingo. I'm going to ask at the end who got the most correct. So I'm going to put up a picture, I'm going to give you a few seconds to think about it. You're going to be marking yourselves, so you have to be honest. You have to say to yourself who it is, perhaps write it down if you've got a pen, and we're going to see at the end who's got the most. If anybody's got 16, they're going to be taken to a psychiatric hospital immediately. But the person who gets the most is going to get a prize. Elena has said that there will be a prize. So on we go, okay? Let's see how this goes. So there we go. So the story that I'm going to be telling you is largely focused on an iconic decision of the House of Lords in 1913 called Scott and Scott, of which I'm sure you've all heard. There have been many cases citing Scott and Scott. The official law reports, the ICLR, list 332, of which 65 were family cases and 267 were civil cases. It's been cited in the House of Lords or the Supreme Court 23 times. It's been cited in courts all over the world. To put the significance of the decision in context, the official law reports list 259 cases which cite Donoghue and Stevenson. It's possible that Scott is the most cited case of all time. This is the iconic decision on which the principle of open justice rests. So here's your first picture. Okay, who is this? Who did this? Have you all thought? It's Earl Lawburn, who was Lord Chancellor between 1905 and 1912. Scott was heard in 1913. He just ceased being Lord Chancellor to be replaced by somebody else who we'll come to in a minute. And he gave the momentous phrase he coined, the traditional law, English justice must be administered openly in the face of all men, and I'd add women, of course, is an almost priceless inheritance, hence the subject of this talk. And he went on to say, the divorce court, because Scott and Scott was a divorce case, is bound by the general rule of publicity applicable to the High Court and subject to the same exception. And the next one, we'll see if you get this one, okay? Now, who is this? This is Lord Atkinson, who was one of the law lords. He was Irish, Attorney General for Ireland between 1895 and 1905, and he said this about open justice. The hearing of a case in public may be, and often is no doubt, painful, humiliating, or deterrent to both parties and witnesses, and in many cases, especially those of a criminal nature, the details may be so indecent as to tend to injure public morals. But all this is tolerated and endured because it is felt that in public trial is to be found, on the whole, the best security for the pure, impartial, and efficient administration of justice, the best means of winning for it public confidence and respect. And it's this little paragraph which is cited most often as being the core reason why we have trials in public. Right, now the next one then. Who's this? Now this is the Lord Chancellor himself, Viscount Haldane, who took over from Earl Lawburn in 1912. And he said this, and this is the test that the common law requires to be applied if open justice is to be derogated from, either by exclusion of people from the courtroom or by anonymization or reporting restriction order. So this is the common law test. Unless it be strictly necessary for the attainment of justice, there can be no power in the court to hear in camera either a matrimonial cause or any other where there is a contest between the parties. He who maintains that by no other means than by such a hearing can justice be done may apply for an unusual procedure, but he must make out his case strictly and bring it up to the standard which the underlying principle requires. He may be able to establish that subsequent publication must be prohibited for a time or altogether. And then this is the key phrase. He must satisfy the court that by nothing short of the exclusion of the public can justice be done. So in that famous divorce case, in fact it was a nullity case, that is the test, the common law test that was formulated, which is still the common law test. A person seeking a derogation from open justice must satisfy the court that by nothing short of the exclusion can justice be done. Now, who is this? Now, I just would like to pause here. What has been the distinguishing feature of I think it's facial hair thing, but this is a magnificent moustache. Now, who is this? No? This is Lord Shaw of Dunfermline, who became a law lord in 1909 and was Lord Advocate between 1905 and, a slight mistake, and 1909. The other member of the panel who heard it was the Earl of Halsbury, and it is quite interesting that all of them had been politicians before they became law lords or went to sit in as additional judges in the House of Lords. They were all politicians. They weren't all professional judges and hadn't or practiced as exclusively as barristers. And he said this: if the judgments declaring that the call should be heard in camera and finding Mrs. Scott guilty of contempt for disclosing a transcript of the proceedings to her father, her sister, and a friend were to stand, then an easy way would be open for judges to remove their proceedings from the light and to silence forever the voice of the critic and hide the knowledge of the truth. Such an impairment of right would be intolerable in a free country, and I do not think it has any warrant in our law. Had this occurred in France, I suppose Frenchmen would have said in the age of Louis XIV, and the practice of rete de cachet had returned. So he wasn't pulling his punches. He was thinking that the decision to hold that case in camera was borderline plunging us in the direction of the French Revolution. So, and yet, now this is a not very difficult one for you, okay? So if anybody doesn't get this, I would be surprised. So who's this? Okay. And yet, I say, in Clibbery and Allan in 2002, Sir Matthew Thorpe, Lord Justice Thorpe, says this, and I ask you to keep in mind when I show you this next slide, the dictar which I've just put up to you from the House of Lords in Scott. I have no difficulty, he said, in concluding that in the important area of ancillary relief, all the evidence, whether written, oral, or disclosed documents, and all the pronouncements of the court are prohibited from reporting and from ulterior use unless derived from any part of the proceedings conducted in open court or otherwise released by the judge. Now, I'm sure you can all see that that statement and what the House of Lords said in 1913 are completely irreconcilable. And so in order to understand that, I'm going to have to do a little bit of history with you. I tell you that in Clibbery and Allan, that particular judgment of Lord Justice Thorpe is the lodestar authority for those to adhere to what I have called the cult of secrecy in financial remedy cases. It is what entirely obiter. The President, Lady Justice Butler-Sloss, does not agree with it, nor does Lord Justice Keane. And for those of you who are interested, the paragraphs in which Lady Justice Butler-Sloss sets out her views are 70. I've set them out there, and you can read them for yourself. Time doesn't permit me to read those out. It stands, as I've said already, in obvious and glaring contradiction to the general law. I contend there's no lawful basis for what was advanced, and in order to make good this contention, it is necessary for us to look at a little bit of history. Now, if anybody gets this, I'll be surprised, but this is a tremendous good example of Victorian facial hair, I would suggest. Okay, now who is this? Has anybody got any idea of this one? This is the first judge of the new court that was invented in 1857, the divorce court. And he is called, believe it or not, Sir Cresswell. Now, I always wondered what his parents, when they were at the christening, and the priest says, how do you name this child, Mr. and Mrs. Cresswell? And they said, Cresswell. Now, maybe she was asking her husband a question. Cresswell? Anyhow, so Cresswell. The Matrimonial Causes Act of 1857 abolished the jurisdiction of the ecclesiastical court. The ecclesiastical court heard its proceedings in public, but I haven't got time to go into all that. It's all in the monograph. It instituted divorce. A new court was created, the Court for Divorce and Matrimonial Causes, headed by the Judge Ordinary. No ordinary judge. I mean, I make this joke so many times, but you know what I mean. An ordinary as in the sole representative. The first was Cresswell, and the court had uniquely, for the first time in the history of English law, the power to dissolve a marriage on the ground of adultery, if the husband was petitioner, or aggravated adultery, if the wife was a petitioner, to annul a marriage, to award alimony, to settle property, and 2 years later, the power to vary nuptial settlements. So this was the revolutionary act that brought judicial divorce into the light. Now, Section 46 of the Matrimonial Causes Act 1857 said this: the witnesses in all proceedings before the court shall be sworn and examined orally in open court. The parties could verify their cases by affidavit, but they were to be subject to be cross-examined by or on behalf of the opposite party orally in open court. That's what it said. There was no power at all to hear evidence behind closed doors in any type of case. So when I showed you Lord Haldane's common law exception, they had to swallow hard when they promulgated that, because they knew that, in fact, Section 46 didn't allow it in any type of case. But the law lords just managed to say that if justice could not be attained, and by no other reason other than exclusion could justice be done, they carved out an exception. But they were doing it in the face of Section 46, which said that there was no power to hear evidence behind closed doors in any type of case. And then the rules that came out at the same time said, the hearing of the cause shall be conducted in court, and counsel shall address the court subject to the same rules and regulations as now obtained in the courts of common law. Well, this is all. During the passage of the 1857 bill and the 1859 bill, because there was another one in 1859, attempts were made to amend the legislation to allow for hearings in private for the sake of public decency. Both were rejected by the House of Commons. But the judges openly defied Section 46, and numerous cases were heard in private, including the case of Scott, where a registrar made a pro forma order that the case was to be heard in camera. A pithy summary of what happened in Scott was given in the Court of Appeal by Sir Herbert Cosens Hardy, the Master of the Rolls. He said this: "It was an action instituted by a wife for a decree of nullity. The usual order was made, the cause should be heard in camera. It was so heard, and a decree of nullity was granted. The wife and her solicitor got copies of the shorthand notes and sent copies so obtained to her father, her sister, and a friend. A motion was made by the husband to commit them for contempt. Mr. Justice Bargrave Dean held they had been guilty of contempt, but accepted an apology from them. He made no order of an order for costs. From this order, there was an appeal to the Court of Appeal. That appeal to the Court of Appeal was dismissed. The second appeal was allowed, as we know, by the House of Lords in trenchant terms in Scott versus Scott." What did Scott decide exactly? Let's look at this. The head note says, and it's very carefully phrased, 1, the order to hear in camera was made without jurisdiction. 2, that the order, assuming there was jurisdiction to make it, did not prevent the subsequent publication of the proceedings. And Earl Lawburn said, "To say that all subsequent publication can be forbidden, and that everyone can be ordained to keep perpetual silence as to what passed at the trials." That's actually my phone. I'm just sorry about that. And to keep perpetual silence as to what passed at the trial is far in excess of the jurisdiction and is, as he put it, an unwarrantable interference with the rights of the subject. It is not that a court ought to refrain from exercising its power in such a way. It is that the court does not possess such a power. That's drawing the same distinction that the Supreme Court did recently in the Wolverhampton case, the difference between having the power at all and when it is proper to exercise or improper to exercise a power. Lawburn seems to be saying here, you haven't got the power at all, but as Viscount Haldane has already given an example of how there is a power, but in very narrow circumstances, I don't think he's been completely literal. All the law lords accepted that on exceptional facts, the court had an inherent common law power to sit in camera and to make a consequential order prohibiting the parties from making a subsequent publication of the evidence. All accepted that the paradigm example of this type of case, the type of case that would justify exercise of the power, was the trial of an issue about a trade secret. If it were not held in camera and subsequent publication prohibited, the very subject matter of the action, namely the secret, would be destroyed by the process. So they all agreed, all 5 of them agreed, that litigation about a trade secret should be heard in camera, because otherwise the process would in fact destroy the very subject matter of the cause. So Earl Lawburn said, "Yet nothing can be more clear than that an order for a hearing in camera of a trial involving a secret process must be utterly illusory if the evidence could be published afterwards with impunity. There must be some power to prevent that, or the undoubted assertion by the very highest authorities to close the court in such a case would be reduced to an idle mockery." Okay, so we're making some progress. There is an exception. It's for secrets, trade secret, litigation about secrets, and the court can make a consequential order that when you walk out of that court, you can't go and give an interview to a journalist about what's happened. So it's a closed court with consequential order for secrecy. So certainly, I asked myself, what power was the court exercising to make that consequential order? Close the court, that's part of its inherent powers, how it manages a case. What power did it have to make a consequential order that you must remain silent? Well, in section 25, subsection 8 of the Judicature Act 1873, which is now in almost identical terms to section 37 of the Senior Courts Act 1981, the court can make an injunction when it's just and convenient to do so. We all know that. And they had, even by then, in 1913, developed a spy-catcher power to bind third parties by notification of the injunction. That's a well-known case of Seward and Patterson. So they had the power, they certainly had the power, to make the order preventing onward publication. So when the law lords said that there is no power to make an in-camera plus subsequent publication prohibition order in a nullity case, they don't mean that the court does not have the varies to clear the court and make such an order. Rather, they're saying it would never be proper to exercise that power in a nullity case, no matter how private and personal the subject matter. And then they said, and this is very important in the context of what I'm saying tonight, any change to that rule was a matter for Parliament alone. Viscount Haldane said, "A mere desire to consider feelings of delicacy or to exclude from publicity details which it would be desirable not to publish is not, I repeat, enough as the law now stands. To justify an order for a hearing in camera, it must be shown I always love the way they shown that the paramount object of securing that justice is done would really be rendered doubtful of attainment if the order were not made. Whether this state of the law is satisfactory is not for a court of justice, but for the legislature. And Earl Lawburn said the same. Some passages in various judgments in this and other cases indicate the court has a right to close its doors in the interests of public decency. Apart from some act of Parliament authorising it, I regret I cannot find warrant. It may be true that the publicity given to obscene or bestial matters by trial in open court suggests imitation, as many judges have learned from experience as assizes, and however deplorable it may be, they have no power to prevent it. The remedy must be found by the legislature or not at all. So if you don't like the law, which says open justice, it's fully open justice, and it's only in that very narrow case where the subject matter of the litigation would be destroyed if it were heard in open court. If you don't like it, then go to your MP, is what they're saying. He did say, en passant, that Earl Lawburn said, if the court is satisfied that to insist upon publicity would reasonably deter a party from seeking redress, this is an argument that comes up from time to time in the current debates, that you would be, and in fact one of the questions has been sent in, that you would be deterred from seeking justice if you knew it would be an open court, said Earl Lawburn. But as I will show you, we will see that this has been disapproved and that that disapproval has been endorsed by a later Act of Parliament. We will see that. So that particular, and only 1 out of the 5, the deterrence argument is, we will see, dead in the water. So you might, those of you who practice might say, oh, no, hang on, but what about proceedings in chambers? We do all our financial remedy work in private, behind closed doors in the judges' chambers. Does that make a difference? Does that mean that none of these rules, that Lord Viscount Haldane's rule doesn't apply? Now, this is a great picture. Okay. Now, who is this? Now, this is Lord Moulton. He was Lord Justice Fletcher Moulton when the case was heard in the Court of Appeal in 1912, but then he was promoted to become a law lord in 1913, and he became Lord Moulton. He was an apostle. Now, what is an apostle? And they had, in those days, a self-selected group of people, the 12 cleverest people in the country, rather to the 12 cleverest men in the country, I'm fortunate to say. And Lord Moulton was one of the apostles, so he was super clever. And he said this about proceedings in chambers in the Court of Appeal in this case of Scott. The language of the order, that's the pro forma order, provides for privacy at the hearing. It has nothing to do with secrecy as to the facts of the case. I have never heard it suggested there is the slightest obligation of secrecy as to what passes in chambers. Everything which there transpires is and always has been spoken of with precisely the same freedom as that which passes in court. So the fact that it's heard in chambers is purely for administrative reasons and no other reason at all. It does not import any secrecy as to the facts of the case. I just say it was not until 1935 that Parliament Act finally provided in the Section 4 of the Judicature Amendment Act of that year that in any proceedings for nullity, evidence on the question of sexual incapacity shall be heard in camera unless the judge is satisfied in the interest of justice it should be heard in open court. And it was then, in 1935, so it's 21 years after the decision, that the actual decision of the House of Lords was reversed. But it was Parliament. It was Parliament that decided that that particular evidence could be heard in camera, and it wasn't done by judges acting alone in the darkness. Now, this is an interesting little diversion which I shall deal with quite quickly. In August 1914, war broke up, and Parliament passed a number of Defence of the Realm Acts, of which the fourth was passed on the 16th of March 2015, containing provisions for the first time allowing espionage proceedings to take place in camera. This was the first time that it was said. However, those provisions only applied to what is a civil trial by judge and jury, which a defendant who was a British subject could claim, and not to a court-martial where all foreign spies were tried. So during the war, all foreign spies were tried by court-martial. This wasn't provided for in any laws passed by Parliament, and there was no law passed at all saying they could be conducted in secret, but they all were. Now, who's this? Now, if anybody gets this, I should be very impressed. This is Lord Chelseamore. And Lord Chelseamore is a retired Major General who presided over all of the courts-martial of spies. held during the war. No law was ever promulgated allowing courts-martial to sit behind closed doors, and the Manual of Military Law, published in 1914, positively forbade it. But all the trials, they started off hearing parts of the trial in secret, and then they were too busy conducting the war, nobody complained about it, so they then conducted all their trials in secret, so that for example, this is just one example, if you were having your breakfast on the 11th of September 1915, and you opened your Times, you would have read this. Unnamed spy executed, tried by court-martial. It is officially announced that a person who was charged with espionage and tried by general court-martial on the 20th of August and the 21st of August was found guilty and sentenced to death. The sentence was duly confirmed and carried out yesterday morning. That was the entirety that the state allowed of those proceedings to be shown to the people. That was the extent of open justice during the war. Now, during the war, a total of 9 spies were shot at the Tower. Apparently, it was all noble to be shot at the Tower. He was shot in the miniature rifle range at the Tower, and 1 was hanged in Wandsworth Prison following courts-martial, and a further 2 were shot at the Tower following civil trials. Most of these trials were entirely secret. And I do say it's not difficult to see the force of Lord Shaw's doom-laden predictions should the principle of open justice not be observed. It is a sobering story. The monograph refers to a very excellent book on the subject. It's a sobering story about how open justice disappeared downriver during the First World War. But another example of how the principle of Scott and Scott, judges found it so easy to slide behind it. In Macpherson, this happened in Alberta in Canada, the husband was the Minister of Public Works. He petitioned for divorce alleging the wife's adultery. The petition was not defended. You'll remember what Section 46 said about open court. It was heard during the lunch hour in the judge's library in the courthouse in Edmonton behind a door marked private. The suit was not announced in a cause list. The case ended up in the Privy Council, where Lord Blainsborough was very unimpressed, and saying their lordships have felt impelled to regard the inroad on the rule of publicity made in this instance as one not to be justified, and now that it's been disclosed, as one that must be condemned, so it shall not again be permitted. Now, in 1960, I leap forward a few years, Parliament passed the Administration of Justice Act, in which some of the learning in Scott and Scott was put on a statutory basis. Section 12(1) provided that the publication of information relating to proceedings before any court sitting in private shall not of itself be contempt of court, except in the following cases, that is to say, children cases, which include maintenance of a child, Mental Health Act, and since then it's been amended Mental Capacity Act, national security, secret process, and where the court, having power to do, which is what Parliament wrote down, expressly prohibits the publication of all information relating to the proceedings or of information of the description which is published. So looking at this, you can see that in the decision of Scott and Scott, they say that the principal automatic exemption is what they always call wards and lunatics. So that's A and B, wardship, and then mental health. And they don't mention national security they didn't seem to be that fussed about national security before the First World War. But then they've got the secret process, which they discussed in their judgments. And then E, that encompasses Viscount Haldane's common law exception. So but this is, you have to understand, these are the rules about what can and cannot be published up in relation to proceedings in chambers. So if you don't fall within this, then the publication is not going to be of itself a contempt of court. Of course, it could be a contempt of court if it was done deliberately to upend the administration of justice, but of itself it cannot be a contempt of court. Now, that's an easy one. You know, if anybody doesn't get this, I shall be disappointed. This is a very easy one, but it is who? Lord Denning, yes. And he says, about Section 12, the effect of Section 12 is that a newspaper may publish information about proceedings in chambers in a civil action and about the pleadings, affidavits, and reports without any fear of being in contempt of court. And what he means by a civil action, of course, an action which is not listed in Section 12(1)A to D, as I've shown. So you've done very well getting Lord Denning, but here's another one. I think about half of you will get this, I should think. Who is this? This is Lord Bridge of Harwich in the House of Lords in a case called Pickering, where he said about Section 12, the general rule which the section declares is that it is not a contempt to publish information relating to proceedings in court merely because the proceedings are heard in private. But exceptions are expressed, A to D, and these must indicate that it is prima facie a contempt to publish information relating to the proceedings in the cases indicated. So there we have cases heard in chambers. It is not a contempt to publish what has happened in a routine financial remedy case unless it is a Schedule 1 case, a case about the maintenance of children. If it's about the maintenance of children, or if it's about the care and control, what we used to call custody, care and control of children, then that would be a contempt. So it's very important to see what Parliament did in 1960. It drew this clear dividing line between those which were heard in chambers, which would be a contempt if you published anything about them, and those that would not, and those that would not encompass regular, routine financial remedy cases. Now, this is a slight point for the geeks here, a technical point. Section 62, subsection 7 of the Children Act 2004 inserted into the Courts Act section 76(2)(a), which said this: family procedure rules may, for the purposes of the law relating to contempt, authorize the publication in such circumstances as may be specified of information relating to family proceedings in private. Now, we've seen from section 12 of the Administration of Justice Act that cases about children, it is a contempt to disclose any details of the proceedings. And what this allows the Rule Committee to do is to say, it's to carve out exceptions, to say, and as we'll see, they did it in children's cases, you can show a copy of you can show a copy of the judgment to your MP, to a legal advisor. You can show it to the European Court of Human Rights. You can show it to a police officer. So it's all set out, a list of people to whom you can make a disclosure. But to make the obvious point, that the section only allows rules to be made which authorize publications for the purposes of the law relating to contempt. So a rule can say that a publication which would have been in breach of section 12 will no longer be in breach, but what it cannot do is the other way around. It cannot say that a publication that does not fall within section 12 and therefore does not amount to a contempt will become a contempt in the future. It can't convert disclosure which is not a contempt at the moment into one that is. So as I was indicating, the currently authorized publications are in the rules. They're for children proceedings. They allow transparency orders to be made in those cases, and it is important to note that these rules, it's barely believable, which permit disclosure to various people and bodies only apply in children and adoption proceedings and don't apply to financial remedy proceedings. Now, you may think they don't apply to financial remedy proceedings because it's not a contempt to disclose them anyway, but we'll see that there's a wrinkle to be addressed on that. But I would respectfully suggest that it is self-evident that if the Rule Committee is prevented by an Act of Parliament for making something that is presently not a contempt into a contempt, then it's impossible for a judge or the judiciary to do so by issuing practice guidance or judgments, I would respectfully suggest. Now, going back to the authorities, in the official law reports, there was a sort of gap between 1932 and 1967, but until the case of B against the Attorney General, which was a legitimacy suit by two children acting by their mother, whose position was that she would not proceed with the petitions unless they were heard in private. She relied on Earl Lawburn's deterrent exception. Do you remember the deterrent exception I spoke about? Mr. Justice Wrangham doubted that that was the law, noting that the other four law lords did not adopt it. And he held that it was not the law, that there was no deterrent exception, and he therefore had no power to hear the legitimacy suit in camera. And in consequence, Parliament passed the Domestic and Appellate Proceedings Restriction of Publicity Act 1968, Section 2 of which permitted legitimacy suits to be heard in camera. And so Earl Lawburn's additional common law reason for holding a case in camera, namely the deterrence point, is completely, I suggest, dead in the water. Anonymity. Lord Sumption said this in 2019. The inherent power of the courts extends to making orders for the conduct of the proceedings in a way which will prevent disclosure in open court of the names of parties or witnesses or other matters, and it's well established that this may be a preferable alternative to the more dramatic course of sitting in private. Now, anonymity is, of course, the way in which open justice is commonly derogated from now. It's a very rare case where an exclusion order is made. In fact, I can't think in my entirety of my practice ever having seen an exclusion order made, but I've seen in the Court of Appeal, for example, them saying that the orders being made that the case should be heard dealt with anonymously. Now, okay, who's this? This is an easy one for you. Yes, Lord Neuberger. He said in 2012, anonymity is an exception to the principle of open justice. It can only be ordered where strictly necessary. And I'd ask you to bear that in mind. And I would say, logically, the test must be the same as for exclusion. It must be the same as Viscount Haldane's common law test. And I'd just add here, the off-quoted statement of the Lord Chief Justice in Crown and Sarker, that any derogation from open justice must be established by clear and cogent evidence. Contra mundum orders. Now, these became put on a statutory basis by Section 11 of the Contempt of Court Act in 1981, which said that in any case where a court, again, where it has power to do so, allows a name to be withheld from the public, the court may give such directions prohibiting the publication of that name or matter as appears to be necessary for the purpose for which it was withheld. This allows a formal statutory order, contra mundum, so that the order applies to the whole world, but such an order under Section 11 can only be made if the name or matter has not been mentioned in court already. So if that has happened, and if Section 11 is not possible, then you go back to the pre-1981 technique, which is you make an anonymity injunction against the parties and you serve it on the press relying on the spy-catcher principle. It's all in the monograph. I don't have time to, I'm sure you all understand what the spy-catcher principle is. Now, post the Human Rights Act 1998. So we've got the position here. I'm just asking you to contemplate. Imagine today is the 1st of October 2000. This is the day before the Human Rights Act comes into force. What is the position about a financial remedy case not falling within Section 12? Well, we've seen that Viscount Haldane's you can only make an order excluding the public or imposing anonymity or imposing a reporting restriction, making a reporting restriction order where you are satisfied that such an order is strictly necessary for the attainment of justice. And which means, as Viscount Haldane said, you must be satisfied that by nothing short of exclusion or anonymization can justice be done. So at that point, that common law reigned supreme. And so the Human Rights Act comes into force the following day. And it says, Section 6, that it's unlawful for a public authority to act in a way which is incompatible with a convention right. And the public authority includes the court. So this could well represent a change, perhaps an important change in this particular field of law. Now, who's this? Anybody got this one? Yeah, I heard somebody. Yes, it is Lord Steyne. Excellent, yes. And he gave the speech in the seminal decision of Ries in 2005, where he said that the House unanimously takes the view that since the 1998 Act came into force, the earlier case law about the existence and scope of inherent jurisdiction need not be considered in this case or in similar cases. So we could have seen when he said that, Viscount Haldane, is that goodbye to you, Viscount Haldane? The foundation of the jurisdiction to restrain publicity now derives from the convention rights under the European Court of Human Rights, European Convention of Human Rights, forgive me. He goes on to say, in oral argument, it was accepted by both sides, the ordinary rule is that the press may report everything that takes place in a criminal court. I would add that in European jurisprudence, this is a strong rule. It can only be displaced by unusual or exceptional circumstances. And then the famous balancing exercise, he says, that should be undertaken. Neither Article 8 or 10 has precedence. Where the values are in conflict, an intense focus on the comparative importance of the specific rights is necessary. The justifications for interfering or restricting must be taken into account, and the proportionality test must be applied. So this seemed to suggest that the common law was retreating into the distance and it was to be replaced by this brave new world which involved this intensely focused balancing exercise. But, there's always a but. Now, who is this? Yeah, that's an easy one, isn't it? That's Lord Sumption. He said in Cuja, in deciding what weight to give to the right of the press to publish proceedings in open court, the courts cannot, simply because the issues arise under the heading private and family life, part company with principles governing the preemptive restraint of media publication which have been accepted by the common law for many years in the cognate areas of contempt and defamation and are reflected in a substantial and consistent body of statute law as well as in the jurisprudence on Article 10. Come back, Viscount Haldane, he's saying. Come back. Don't leave the room. Who's this? Yes, who's the President of the Supreme Court. And this one? This is Lord Briggs. And in Abbasi, which is decided this year, 2025, which I regard, I've come to the conclusion is extremely important in this area of open justice. They say this at 89. The court does not act in a way which is incompatible with convention rights by insisting that individuals avail themselves of the domestic cause of action which is available to protect that right, and that the action is brought by the individual whose convention right is in issue. And at 98, the general rule is that parties should protect their convention rights by availing themselves of the appropriate cause of action under our domestic law. Then they say, if a cause of action is not available or fails to provide practical and effective protection of the convention rights, the court can exercise its broader jurisdiction under Section 37, read with Section 6, and then this is me. This approach means, I'm saying, that the invocation of direct protection of the convention rights is to be used as a safety net rather than the first and last port of call. We'll come on to that in more detail. And then they say, rather surprisingly, in 93, Lord Staines's reasoning in Re S, where he went directly to Section 6 without pausing to consider the availability of domestic remedies, was highly unusual, they said. And they said that the law had moved on since Re S. The courts are now willing to develop the common law when necessary in order to meet the requirements of the Convention, and have deprecated the tendency to see the law solely in terms of the Convention itself. This, I suggest, is a major change. Now, who's this? This is Lord Justice Warby, who said in Millicom, the effect of the Human Rights Act is not that the Convention supplants or replaces domestic statutory or common law rules. Rather, it provides certain guarantees against the enforcement of those rules to the extent it would be incompatible with fundamental human rights. As Mr. Callis has conceded, it is not necessarily the case that the answer given by the common law will be the same as that arrived at through a convention analysis. And if the two are difficult, that does not necessarily mean the common law answer is incompatible with the convention. So I suggest this. The court's correct approach where an anonymity order is sought is first to identify and invoke an available cause of action. That would be Viscount Haldane's common law exception. If that answers the question positively, then the order may be made and consideration of convention rights simply doesn't arise. If the answer is negative, then it's only at that stage that the competing convention rights come into play and are to be weighed. But, and this is entirely me, okay? Now, this may be shot down in flames. Trust me, I'm quite used to that. This does not mean, I suggest, that one starts the weighing exercise with the pans empty and the scales balanced. The idea of a metaphorical weighing exercise beginning with the scales imbalanced because of the presence on one pan of a particularly important juridical principle was given by the Supreme Court in the Nigerian airports case, where the principle in question was the finality of litigation. Lords Briggs and Sales said this: the question is whether the factors favouring reopening the order are in combination sufficient to overcome the dead weight of the finality principle together with any other factors pointing towards leaving the original order in place. So here, I suggest, the weighing process, if one gets that far, starts with the dead weight of the open justice principle already in one of the pans, to which will be added the specific factors militating in favour of full publicity. And the question is whether the specific factors in favour of anonymity can overcome that combined weight on the other side. That's what I suggest. And I would also refer to the case of Morandi, where I was privileged to sit with Lord Justice Warby in that case. It was one of my last cases that I heard. Lord Justice Warby said that clear and cogent evidence is needed as the court is, as he puts it, evaluating the claimant's case against the weighty imperatives of open justice. So this is my anonymity test. This is me, in which I have spent hours trying to work out how do I reconcile the common law and the European Convention on Human Rights. This is how I do it. The facts relied on must be proved by clear and cogent evidence. If those facts show that by nothing short of anonymization could justice be done, then it may be ordered under the common law. Only if the common law answer is negative does the court balance the competing convention rights engaged by those facts. In that evaluation, the open justice principle itself must be reckoned as a weighty factor in favour of publicity. Any restriction of freedom of expression must be justified by a pressing social need. I explained that in the monograph. Ultimately, it must be shown that anonymity is strictly necessary for the attainment of justice. That is how I believe an application for anonymity is to be intellectually reasoned and decided. There is this very important epilogue from Lord Steyne. It needs to be said clearly and unambiguously that the court has no power to create by a process of analogy, except in the most compelling circumstances, further exceptions to the general principle of open justice. And Lord Sumption said the same thing in 2019. He said, I won't read it out, you can read it for yourself as we're slightly pressed for time. So I now turn to financial remedies practice, which is the object of my criticisms this evening. Between September 23 and March 25, 84 judgments were published by the Financial Remedies Court, of which 71 were anonymised, and 7 contained any reasons for anonymisation at all. And not one of them came near to Lord Haldane's test. 13 complied with the open justice principle and were published fully with names. 48 of them, of the 71 anonymised, had a rubric, which is a notice stuck on the front of the order, threatening contempt of court proceedings if the anonymity of the order was breached, even to a legal advisor or a spouse, without limit of time. Not one of these orders, not one of these judgments, which had this rubric affixed to it, was there an order made either under Section 11 of the Contempt of Court Act, or Section 6 of the Human Rights Act, or Section 37 of the Senior Courts Act. It was just a notice on the front of the judgment. And this is what it said. This is what on the front of 41 of them had, that's over half of the published judgments. This judgment was delivered in private. The judge has given leave for this version of the judgment to be published on condition, irrespective of what is contained. In any published version of the judgment, the anonymity of the children and members of their family must be strictly preserved. All persons, including the media and bloggers, must ensure this condition is strictly complied with. Failure to do so may be a contempt of court. Now, that is a very, very good rubric in a children's case, which is governed by Section 12 of the Administration of Justice Act. What has this got to do with a money case? They might not even have any children. But this appears on the front of almost all money judgments. And why do they do it? It's because the judgment generator generates one rubric, one template of a judgment for every type of case, and they don't bother to change this. But it goes out, and people sit in their living rooms, and they want to talk to their wife about it, and they say, I can't talk to you about this, my judgment, because there's this notice on the front. The Financial Remedies Court is presently subject to a national pilot scheme, which is not operating under Part 36 of the rules, which is the provision in the rules which allows pilot schemes to take place, but under guidance issued by the President, which does not appear to be approved by the Rule Committee, the Lady Chief Justice, or the Lord Chancellor. I have pages of this in the monograph, and I think you will find it quite interesting. The pilot scheme recommends that in every case where a reporter attends the hearing, a reporting restriction order should be made without limit of time in the following terms. This is what it says. A reporter, it will remain in force until further order. A reporter may publish any information to the degree, save to the degree restricted below. No person may publish any information relating to the proceedings to the public, which includes the names and addresses of the parties, including interveners, the children, photographs, the schools, identity of their employers, the names of their businesses, their place of work, their address of any land they own, the identity of any account or investment held by them, the identity of any private company or partnership in which any party has an interest, or the name of any witness or of any other person referred to in the hearing, save for an expert witness. So that means not even the name of the judge. Okay? So that is what the guidance issued by the President says should be, an order should be made in every case if a reporter turns up. Now I say this purports to convert presently permissible disclosures into contempt of court. This is far fiercer than the rubric I showed you earlier. What are we to make of this? How has something so at variance with the general law been allowed to happen in plain sight? The answer is that Lord Justice Thorpe greenlit it in Clibbery and Allan. Ironically, the decision in Clibbery allowed the Part 4 judgment to be fully published, and in the judgments, the President herself felt that the exclusion of the public, because those were the days before when proceedings were heard in chambers and the press were not allowed in, gave some limited privacy to matrimonial litigants, but in 2009 a rule change let the press in, and the legality of formally excluding the public has never been tested and is not consistent with Scott. That's all in the monograph. Lord Justice Thorpe pronounced, as we've seen, this blanket ban on everything said in court, of all the evidence and anything said by the judge, including in the judgment. On what basis did he say that he could do this? He relied on the duty in ancillary relief proceedings to give full and frank disclosure, and he relied on the implied undertaking not to use any documents disclosed to you for ulterior purposes as showing an intrinsic difference to civil proceedings. He suggested there was no duty of disclosure in civil proceedings. He said this: in civil proceedings, the parties bring into the arena such material as they choose to bring, together with such material as they may be ordered to bring during the development of the case. In contrast, he said, in ancillary relief application proceeds on a very different basis. The litigants may not bring into the proceedings such material as they think fit. They're under a duty of full and frank disclosure. He's quite wrong. The obligation under CPR 31.6b, when giving standard disclosure, is to disclose all documents which adversely affect your case, adversely affect another party's case, and support another party's case. The obligation of disclosure under standard disclosure is just as exacting as the family division standard. His reliance on the implied undertaking is baffling because it's expressly legislated in the rules, and I set it out there. And in any event, at common law, the undertaking doesn't apply to a journalist covering the case. That's Harman and the Home Office, Lord Diplock and Lord Roskill. So that is totally irrelevant. These are the reasons that Lord Justice Thorpe gives for saying that you can have blanket secrecy in ancillary relief proceedings, and his arguments are, with all due respect, completely untenable. It is in maximum conflict with Scott. I say that only legislation can turn something that was not a contempt into a contempt, yet that is what Lord Justice Thorpe seeks to do. His pronouncement reverses the burden of proof. Someone seeking anonymity should have to show why it's in the public interest that anonymity should be granted. Lord Justice Thorpe puts it the other way up and upends that key principle. He subverts entirely the exceptionality of the remedy, Lord Neuberger. He pays no regard to the principles enunciated by the House of Lords in Scott. It pays no regard to the importance of the open justice principle itself and the dangers faced by society where secret or semi-secret justice becomes the norm. It has led to thousands of litigants being wrongly threatened with fines and imprisonment if they talk about their judgment with anybody, including their own families. Thousands. It is a scandal, I suggest, happening in plain sight. My personal view is that unless the case is protected by Section 12, it is not in the public interest for parties to be anonymous for the reasons given by Viscount Haldane, Lord Atkinson and Lord Shaw back in 1913. But I acknowledge fully there is a strong view held by many, maybe many of you are here, by lay people, professionals and judges, that financial remedy cases should be treated as a class apart from ordinary civil litigation, and that as such the extensive anonymity spelt out in the draft order is right and just for such cases. Okay, I acknowledge that, but I do strenuously maintain that if this view is to be vindicated, it must be achieved in the High Court of Parliament and not in the High Court of Justice. I end, we're at the end now, if I don't know what I've done all right, with this prescient declaration from that apostle, Lord Mostyn. Nothing would be more detrimental to the administration of justice in any country than to entrust the judges with the power of covering the proceedings before them with the mantle of inviolable secrecy. So that is the end of my speech. I want to show you, just ask a favour of you. We have a petition, those of us who've got Parkinson's, to Parliament. We need 100,000 signatures to get a debate in Parliament to try and have a debate on the really, frankly, abysmal care that is made for people with Parkinson's. And so I'm going to ask you to sign the petition, okay, if you've got a moment. The link is called parkypetition.com, and if you could just take your cameras out, and if somebody could take a photograph of somebody if you could just take a photograph of that, and if it takes 1 minute to fill it in, We've got 57,000 signatures so far. We need 100,000 by September. If we get the debate, we may be able to address the problem, which is the average waiting time for somebody to see a neurologist in this country is nearly 2 years. 2 years being unsupported. And that the number of neurologists in this country, out of 48 countries in Europe, we're at number 47. So it is the standards that are given for people with Parkinson's. And so if you could just fill in that in, I'd be extremely grateful. Thank you very much. So, hang on, a very important thing. Did anybody get 16? If you do, you need help. But let's go. Let's see. Did anybody get 10? Did anybody get 10? Did anybody get 9? Did anybody get 8? You have won. Identify yourself. Congratulations.